Well, let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu Malat. That argument has already been made. I'll not repeat it, Malat. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malat. It's already been argued. Now come to Malat to Article 3. PDF 33. Yes. So, Malat, as far as Article 3 is concerned, Malat, let's assume I've made my arguments on the proviso already, Malat, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malat, all this is valid. Let's assume. Malat, how can they make the union, a state into a union territory? Under what provision of law? Okay, under which, what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course, that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malat, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Malat, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, Malat, or basis on the basis of which you can deny the people of Kashmir a statehood, which and Malat, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Malat, just one last thing, and then I'm done. I want to show you the annexures in this, Malat. This is my argument on 3, Malat. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. This is dated 17th May 1949. But as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar. And he tells Vallabhbhaiji, here's the draft. Jawaharlal ji has seen and approved of it. Will you kindly let Jawaharlal ji know direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes. It's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, Mullah, of 306A. Kindly come to 244, Mullah.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the Constitution. 1 second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead and do it. Now see the next document, 3rd November. There was some, again this is by Vallabhbhai Patel, there was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Malats, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure enough flexibility at later
absolutely. All I'm saying is that everybody was part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Marat, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already
I've already made. I'm not repeating it, Marat. I just wanted to read these letters. So, Marat, and then I've got this table, Marat, of Jammu Kashmir, Marat, where Jammu Kashmir is the head of most of the states in India in every parameter. But we are not concerned with that, Marat. I just put it. So that's all I have to say, Marat. I just want to say at the end that, Marat, as I said, Marat, your lordships, Marat, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Because people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time. Excuse me for a while. Let's fill it.
Mr. Subramaniam, you'd be
Yes,
arguing.
my lord. My lord, am I audible? Am I visible?
Mr. Subramaniam.
Yes.
Thank you, my lord. My lord, I just want to make a few brief submissions on Article 370 in the light of your lordship's questions and observations. My lord, it might have begun as a temporal provision initially. I don't think anybody can dispute that people envisaged it as of temporality. But, my lord, the provision had adequate evidence, intrinsic evidence in its words to suggest that it could be there to stay. And that is what has happened. And, my lord, this is the crux of the matter. Has it happened in a manner known to Article 370? My answer, my lord, is yes. In a manner known to Article 370, Article 370 stays. Now, my lord, how has this been achieved? As your lordships would notice, that it was a Constituent Assembly of India which gave the people of Jammu and Kashmir the ability to determine their political future through a constitution. The instrument of accession, my lord, did not completely transfer sovereignty, as held by Justice Gajendra Gatkar in Pramnath Kaul's case. The instrument of accession itself had reservations that it was intended to abide by a future constitution, a future determination by the people of India, which is why Justice Gajendra Gatkar said that until the 1939 constitution was there, the Maharaja was still enjoying a certain kind of sovereignty to make laws, and therefore, my lord, upheld the law in question. Now, my lord, when does integration become complete is the question. And, my lord, in this case, unlike the cases of privy purses, unlike any other case, the sovereignty actually transfers from the king, from the monarch, to the people. And this transition from the monarch to the people is the common framework of both the Constituent Assembly of India and a Constituent Assembly to be formed. The notification of 25th November 1949, my lord, expressly uses the words Constitution as applicable, or insofar as is applicable, because that is how Article 306A of the draft Constitution presaged it. Well, on Article 306A is the only article which refers to the instrument of accession and refers to the matters contained in the instrument of accession as limiting the power of Parliament to make laws. Therefore, my lord, the instrument of accession expressly finds a place in Article 371 of the Constitution. The expression Constituent Assembly also finds a place in Article 370 of the Constitution. But there was a very important question which the Chief Justice has voiced on a few occasions. What is there to show that the Indian Constitution recognized the Jammu and Kashmir Constitution? I thought it was a very critical question, and I have, my lord, two answers. The Constitution does recognize the Jammu and Kashmir Constitution. May I invite your lordship's attention to the text of Article 370 itself that recognizes, my lord, that Constitution. Please, my lord, look at Article 370 with me for a moment. In Article 370, after subarticle 1, 2, and if your lordship sees 2, if the concurrence of the government of the state referred to in para 2 of subclause B of clause 1, or in the second proviso to subclause D of that clause, be given before the Constituent Assembly, and may I request, my lord, your lordships to look at the next few words. For the purpose of framing the Constitution of the state is convened. Constitution of the state, my lord, is no other constitution except the Jammu and Kashmir Constitution. And, my lord, there is a second piece of evidence in the Constitution, which has not yet been brought to your lordship's attention. There was, my lord, the state reorganization in 1956. The concept of Part B, Part C, all of them disappeared, if your lordships recollect. The Constitution's 7th Amendment Act, my lord, in Article 152, inserted the words excluding the state of Jammu and Kashmir. In Article 152. This is, my lord, 7th Amendment. And, my lord, the dates are slightly significant. Very important, my lord, is the date. The 7th Amendment was assented, my lord, on the 19th of October 1956. And, my lord, by this time, the draft constitution of Jammu and Kashmir was introduced on 10/10/1956. And the draft constitution of Jammu and Kashmir established the High Courts of Record and established the legislature under its constitution.
What happened on 10/10/56, Mr.?
In 10/56, my lord, the draft constitution of Jammu and Kashmir was introduced for adoption. And that constitution, my lord, clearly had provisions for executive, the legislature, and the judiciary to be established in terms of that constitution. So institutions, my lord, were established under that constitution. And therefore, Part 6 was rendered inapplicable by the insertion of the words in the Constitution's 7th Amendment Act, excluding the state of Jammu and Kashmir. So, my lords, it was a very valid question that your lordships put to us. Is there any evidence, apart from conduct, which I'll deal with separately, in terms of constitutional conduct, that the Constitution of Jammu and Kashmir is alluded or is cognitively taken note of? It is alluded in the words in my submission in sub-article 2, it is cognitively taken note of because the chapter relating to part 6 was rendered inapplicable under Article 152, which is why your lordships notice now the CO 273, it seeks to exclude that exclusion. It refers to 152. It says, notwithstanding anything in this constitution. So, my lord, I submit that the Jammu and Kashmir constitution does find a place. But let's come to a more critical point about the word recommendation in sub-article 3 and whether sub-article 3 was in fact employed. This is a very critical question your lordships asked. The word recommendation, my lord, was chosen consciously because the Constituent Assembly of Jammu and Kashmir, my lord, was not constituted by the Government of India or any initiative of the Government of India. It was under a proclamation of the Maharaja under the Jammu and Kashmir Constitution. That Constituent Assembly, my lord, was not an emanation of the Government of India's Act. Second, my lord, an order which had to be issued under Article 371 necessarily had to be an order in the name of the President. And that's, my lord, because all executive power vests in the President. The argument of President being answerable to Parliament, I'm sorry, my lord, with respect, is completely contrary to the decisions of this court with reference to the Westminster style of government which we have adopted, which Dr. Ambedkar on the 4th of November, when he introduced the Constitution, he spoke about the role of the President. And, my lord, I submit, under Article 81, the President, my lord, is a part of Parliament. I was a little surprised, my lord, to say the President is answerable. My lord, he is a part of the Parliament. Parliament, by very definition, includes the President and two houses, my lord. And under our Constitution, my lord, the President can never act without the aid and advice of the Council of Ministers. The governors could, under Shamsher Singh, but not the President. So, my lord, a claim of untrammeled discretion and power in the President under Article 371 itself, my lord, is flawed. But now, my lord, let's see how events have played out. Your lordships wanted to know, was sub-article 3 employed? Was there anything to show that it was effectuated? And I say, my lord, it was effectuated in 4 different ways. The summum bonum of all the 4 steps is it was effectuated. And, my lord, the decision to abrogate Article 370 cannot be taken ad nauseam. It was meant to be taken once. It had to be taken by the Constituent Assembly. Now, my lord, let us look for evidence of it. The first is, please look at, my lord, CO. If your lordships will look at CO 42. Would your lordships kindly go to the documents volume for a moment? Please go to, my lord, document volume 3. And would your lordships kindly come at page 12 of the PDF. CO 44, I'm sorry, CO 44. Please see, my lord, this. My lord, this is on the recommendation of the Constituent Assembly. PDF 12, my lord. And if your lordship says this is a declaration under Article 373 of the Constitution. And if your lordship now sees the declaration, in exercise of the powers conferred by Clause 3 of Article 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from the 17th day of November 1952, the said article shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted, which, my lord, is about the Sadr-e-Riyasat. But, my lord, this is a decision under 373. What was the next decision? The next decision, my lord, was again a recommendation of the Constituent Assembly, namely an invitation, my lord, to apply the provisions of the Constitution of India subject to certain modifications. That was a decision, my lord, again of the Constituent Assembly. It was a resolution of the Constituent Assembly. And that, my lord, is significant because that resolution was on the 15th of February 1954. The lordships will find that in volume D7 at page 978, and it was adopted in, my lord, D7, page 979. That annexure, my lord, which was the annexure attached to the report of the drafting committee, was tabled in the Constituent Assembly.
Where do we get it? At page 2?
My lord, volume D7. Has your lordship a volume D7?
PDF?
Yes. My lord,
979.
could your lordships first see volume D7 at
Yes.
page 937? Let me show that first.
937.
Yes, first 937, and then I'll show you, my lord, the resolution.
That's the report of the drafting committee?
Yes, this, my lord, was tabled before the Constituent Assembly. And in this report of the drafting committee, your lordships will notice at 938, PDF 938, would your lordships look at the first sentence? The provisions of the Constitution of India, which in addition to Article 1 and Article 370 should apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they should so apply will be as follows. And then, my lord, all these are extracted. But what's important, my lord, is Article 1 and Article 370 in addition. This, my lord, is introduced on the 11th of February 1954. And on 15th of February, 1954, if your lordships go to page 978, my lords, of the same volume, this was adopted. So, my lord, the first body which looked at the matter was the Constituent Assembly. They invited the application of the provisions of the Indian Constitution. And at 978, your lordships will see at the bottom of the page. Please look at the bottom, my lord. Resolution that having adopted the report of the drafting committee this day, the 15th of February 54, and having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the aforesaid report, this assembly authorizes that government of the state to forward a copy of the said annexure to the government of India for appropriate action. And that is how, my lord, on the 14th of May, 1954, the 1954 order was passed. And your lordships will notice the words of that order. It's in volume D3, my lord, at page 13. Your lordships will notice
Volume 3,
that
page number, volume 3.
yes, volume D3, page 13, my lord.
Okay.
Your lordships will find an express continuance of Article 370. Please see page 13. This is the 54 order.
Yes.
And please come to 2. The provisions of the Constitution, which in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. And, my lord, this order of 1954 was again tabled before the Constituent Assembly. If your lordships go to volume D7 at page 990.
So 371, not 373. No.
And at page 990, my lord, your lordships will notice that in the Constituent Assembly, the 1954 order is laid on the floor of the House. Please see 990, Mr. Dogra. The recommendations of the House in this behalf had been sent to the President of India, who in exercise of the powers conferred under Clause 1 of Article 370 was pleased to issue Constitution Order 1954. I lay the copy of this order on the table of the House. As I told your lordships a little while earlier, the draft constitution, my lord, of Jammu and Kashmir was introduced by Mr. Dogra on 10/10/1956. Your lordships will find in the same volume at page 1058. In that same volume. Your lordships will see 1058 PDF.
Page number, please repeat.
Page number 1058 PDF, my lord, in volume D7. Otherwise, it has a red lettered page of 2417.
That's it.
And your lordships will notice, Mr. Dogra, sir, I beg to present the report of the drafting committee and introduce the draft constitution as settled by the committee. And your lordships may just see 4 lines later. The fundamental principle on which the draft is based are parliamentary democracy, responsibility of the executive to the legislature, joint responsibility of the cabinet, separation of the various powers of the state, executive, legislative, and judicial, and finally, the rule of law. One basic feature of the Constitution is that we have once again affirmed that the state is an integral and inalienable part of India and will ever remain so. It was a very thoughtful observation from my Lord Justice Gavai on Dr. Ambedkar's contrast of different models of federalism. But Dr. Ambedkar does say even the Indian Constitution shares sovereignty between the center and the states. However, it does not have the same nature of the American Constitution. It comes to an end there because they have separate constitutions for each state and they have citizenship for each state. But, my lord, here, the word which is used is only permanent resident, not citizen, my lord. All Jammu and Kashmir residents governed by that constitution claimed and asserted that they are Indian citizens. I'm going to show that, my lord, in a moment. Now, this, my lord, is the draft constitution. Now, would your lordships kindly come to 1910-56? You just have to look at Article 152 in your, my lord, in the Constitution. Please have a look at Article 152.
What is the date, Mr. Subramaniam?
That, my lord, came on 19th October 1956. Your lordships will find that at page 101 of the Constitution, PDF.
That is the 7th Amendment.
That is the 7th Amendment, my lord.
It came into force on 1st of November 1956.
Absolutely, my lord. And your lordships will notice the parentheses. This recognizes the J&K Constitution because the establishment of the Raj Pramukh or the governor or the institutions of the legislature, executive and the judiciary were undertaken under that constitution. So your lordships notice in the definition article 152, in this part, unless the context otherwise requires, the expression state and then does not include the state of Jammu and Kashmir. Now, my lord, the constitution of J&K was adopted after this. This is 1/11/56. The date of adoption of the Jammu and Kashmir constitution was, my lord, actually 17th of November 1956. And, my lord, in line with the date of coming into force of the Indian Constitution, they made the effective date as 26th of January 1957. And the J&K Constitution, your lordships will find, is in volume D2. And it is at page 17.
Volume D2.
Page 17, my lord.
So, Subramaniam, what seems to have happened was this. During the period when, after our constitution came into force on 26th of January 1950, Jammu and Kashmir was a Part B state. Now, in relation to the Part B states, Article 238 of the Constitution made provisions for modification of Part 6 of the Constitution.
Right, my lord.
Therefore, to the Part B states, Part 6 would apply with the modifications which were spelled out in Article 238. Article 371A, however, stipulated that
238 will not apply.
38 will not apply to the state of Jammu and Kashmir. Right? Now, that was that period when the constitution was yet to be drafted. After, with the 7th Amendment, Jammu and Kashmir ceases to be a Part B state. It becomes a state within the meaning of Article 1(3)(a) of the Constitution.
Right,
The distinction between Part A, B, C, and the Part D territories vanishes after the 7th Amendment. So when Jammu and Kashmir ceases to be a Part B state, automatically some provision had to be made. It was not governed by Article 238. So other Part B states, which ceased to be Part B states, were governed then by Part 6. Jammu and Kashmir was not within the fold of Part 6 for the reason that so long as the Jammu and Kashmir Constitution continued to hold the field, that Constitution made provision for the executive,
Yes.
the legislature, the judiciary, so on and so forth. So this provision in Article 152 was in continuum.
Exactly.
Because from the inception, Article 238 had no application. And
Right,
once it came within the fold of not a Part B state, you have to make some provision. Now that provision, according to you, was made in the Constitution of Jammu and Kashmir.
My lord, absolutely. This is the point I'm making.
Right, but that doesn't tell us the basic question as to whether that was intended to be a permanent arrangement.
Yes. Now, my lord, for that purpose, if your lordships now take the Jammu and Kashmir Constitution, because, my lord, that's a little important. Your lordships are absolutely right. We have to look for evidence in the instruments themselves. Let's look at the Constitution of Jammu and Kashmir. Because the Jammu and Kashmir Constitution, my lord, actually not only makes integration absolutely beyond any pale of doubt. Unity and integrity with India is beyond a pale of doubt in that constitution. It, my lord, reserves provisions for the application of the Constitution of India in the state of Jammu and Kashmir. My lord, that's quite significant. If your lordship just takes that for a moment, please look at, my lord, their preamble. Because, my lord, what we are concerned with in this case, we have used different expressions like consent of people. We have used the expression people. But, my lord, let us look at their preamble. This constitution was inspired, quite rightly, as my lord the Chief Justice said, by various constitutional provisions. And, my lord, it was many of the exceptions in the 1954 order were also inspired, my lord, I'm going to show to you shortly when we come to Parathe's case, by the American Constitution. But I'll show that in a moment. Please come to the preamble. We, the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof, and to secure to ourselves justice, social, economic, and political. Well, this word, justice, political, will be of some significance in the light of Dr. Ambedkar's own exposition. This is, my lord, a resolve, and therefore they adopt this constitution. What is now, my lord, important is the Constitution of India, and which your lordships will notice is in 2(1)(a). At page 17. The first definition, my lord, is for the Constitution of India. Constitution of India, means the Constitution of India as applicable in relation to this state. And then your lordships may kindly see 3, 4, and 5. Three is relationship of the state with the Union of India. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. Well, Lord, this is a part of a constitution. What is the further integration we are talking about? It is an article of faith. It is a parchment of pride. For the people of Jammu and Kashmir, they have set this in the forefront in Article 3, which is called Section 3 by commentators. Then please see 4, the territory of the state shall comprise all the territories which on the 15th day of 1947 were under the sovereignty or suzerainty of the ruler of the state. And 5, my lord, please notice 5. The executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. But, my lord, under the provisions of the Constitution of India as applied under an order under 371. And, my lord, thereafter, your lordships will
Therefore,
notice
so
Section
Subramanian,
6, sorry.
The domain of the Constitution of Jammu and Kashmir was that which was defined by the Constitution of India.
Yes. Now, my lord, I'm now saying Constitution of India here meant.
Therefore, this was
Yes.
not that. This was not therefore a constitution which was at par or superior to the Constitution of India. It can't be superior to the Constitution.
No, it is not superior. My lord, it's not superior.
Nor was it at par with the Constitution of India, for the reason that look at the two definitions. 2(1)(a).
Yes.
Constitution means the Constitution of India as applicable in relation to the state.
Yes, my lord.
Now, where would we find the nature of the application of the Constitution of India to the state of Jammu and Kashmir? Not in the Constitution of Jammu and Kashmir, but in the Constitution of India.
Agreed. Agreed,
Right.
my lord. That is why your lordships are right.
Right.
Under Section 5,
Right. Section 5 also.
yes, under the provisions of the Constitution.
Legislative power of the state extends to all matters
Yes.
except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India.
Correct, my lord.
Therefore, the domain of Parliament to make laws for the state would be defined by the Constitution of India, not by this Constitution.
I'm grateful, my lord. Now I'm taking you a little closer to the point that if it meant under the Constitution of India, it also meant the order under 371. That's the point I'm making. And, my lord, that way, there is nothing, in this case, my lord, the two constitutions are, I'm not saying this is superior. Please don't get me ever wrong. But, my lord, I would not like to say easily that it is inferior because it has established courts of record and a legislature. It's a constitution, my lord. The Jammu and Kashmir High Court owes its existence to this constitution. The legislature of Jammu and Kashmir owes its existence to this constitution. They have been established, my lord. These are institutions of a permanent nature established under the constitution.
Who would
My lord,
appoint
there is no
judges to the
question
High
of
Court of Jammu and
superiority.
Kashmir? Who would appoint judges to the High Court of Jammu and Kashmir?
Well, that also is provided. The Chief Justice is involved. The Chief Justice of India is referred to. This constitution, my lord,
President will
refers.
appoint judges to the High Court of Jammu and Kashmir.
Yes.
the President would transfer judges from the High Court of Jammu and Kashmir.
Yes. But my lord, I'm saying the establishment of the institutions or their genesis, not to the Indian constitution per se, but to the J&K constitution. My lord, I'm on the establishment of the institutions. Thereafter, they're administered naturally by the Chief Justice of India when appointments are made. But the important point, my lord, is that this constitution creates institutions. But in areas where it allows the Indian constitution full play, it is silent. It creates its institutions. It is, my lord, an additional act of affirmation. But that is what our Constituent Assembly did, my lord. Imagine, my lord, our Constituent Assembly in its wisdom gave space, gave a certain sense of choice to people to determine. My lord, I think nothing could have been greater than that. And likewise, the response of the people of Jammu and Kashmir in their Constituent Assembly, they matched it. They have matched it with the words of this constitution. And my lord, this constitution is also a parchment of pride, my lord. It defines them. It defines their persona. And they are not saying anything else. They're saying it cannot demise. A constitution, my lord, cannot demise. A constitution, my lord, cannot evaporate or eviscerate. Unless, my lord, it is done in a manner known to law. So, my lord, sub-article 3 of Article 370 worked itself out. It was meant to be acted on. They acted on.
You see,
Yes, Mr.
Yes.
Subramanian.
My lord, I wanted to point out, my lord, they even kept out of their amending power in section 147 of the Constitution at PDF page 85. Your lordships will notice section 3, 5, and the provisions of the Constitution of India as applicable, they will never touch. My lord, I don't think the resolve of people is clearer than this. The resolve of a constituent assembly cannot be clearer than this. That they celebrate the unity of India and they say, we will never touch it, will not amend.
Mr. Gopal
Section
Subramaniam,
3.
on one aspect, there is no less at all, is as far as integration into
Yes.
the India is concerned, there is, I don't think any of the sides are at item. So that we accept, that's a foundation on which we have proceeded.
Yes.
And then the issue has arisen with regard to Article 370.
Yes.
The recognition
right.
of the Constitution of J&K will be also, or Constitution of India as applicable to J&K,
That's right.
dedicated and on the basis of Article 370.
That's right, my lord. So now we look at the other two points about the validity of these two actions. Once, my lord, we are clear that the provisions of the Constitution of India as applicable in relation to the state can never be changed, my lord, this is called an acknowledgement in a constitution. It's a total acknowledgement of the Constitution. And, my lord, the question which arises for your lordship's consideration is, if the Constituent Assembly of Jammu and Kashmir and the Jammu and Kashmir Constitution paid such and accorded such supremacy to the Constitution of India, we are now, my lord, coming to the question which Justice Khanna posed, what about the powers under 370? We're coming straight to the point, my lord. What about the powers under 370? My lords, I am not looking at the inconsistencies in the government of India's pleading. I will assume that they can argue anything as long as they can show power and its valid exercise. Let me assume that they can raise any argument, but let them show where is the power and where is the exercise. Now, my lord, let's start with the first. It was suggested that Article 367 was a route. The amendment of Article 367 was a route because we have done it in the past. We have done it once more. Very simplistically put. But, my lord, when was it done? It was done, my lord, in 1954 in CO 48. It was done in 1958 in CO 56. And it was done a third time, my lord, in 1965 in CO 74. Now, my lord, your lordships will be a trifle surprised to know that the modifications to Article 367 in CO 48 and 56, 48, my lord, is at volume D3, page 13, and CO 56 is volume D3, page 25.
Page?
My lord, they provided these two orders when it amended Article 367.
D313 and D325.
Yes, D3, page 13, my lord, and D3, page 25.
Okay.
And if your lordship sees it, My lord, Article 367 was to provide for definition for terms which appear in the order. Please look at it for a moment.
25. That point you made, Mr. Subramaniam?
My lord, that is the amendment proposed in 367 was to define terms in the presidential order. The first two. If your lordship sees 13, my lord, for a moment, I can just demonstrate it straight away. Please come to page 13, my lord, it starts. Please come to 18.
Yes.
For the purposes of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or the provisions thereof as applied in relation to the said state. And your lordships will find references to a high court shall include references to the High Court of Jammu and Kashmir. Reference to the legislature of a legislative assembly shall be construed as including references to the constituent assembly of the said state. And, my lord, likewise, the 58th order, CO 74 of 1965, my lord, please take the dates. It's a little important. The 1965 order was preceded, my lord, by the J&K Amendment, Constitution Amendment Act.
Was preceded by?
It was preceded, my lord, by the Constitution Amendment Act of 1965. My lord, that was enacted on 10th of April 1965. Sixth Amendment Act. And, my lord, the CO 74 in Damnu's case was issued on 24/11/1965. Now, my lord, we come to the question about the power under 370. My lord, any power under the Constitution, my lord, is not untrammeled because we have a controlled Constitution. We have to see whether the power is exercised for the purpose for which it was conferred. And if that purpose, my lord, implies, as my lord the Chief Justice perspicaciously pointed out, either consultation or concurrence, or, my lord, in a one-time decision, a decision of the Constituent Assembly, it is very clear that Article 370 itself negates unilateralism. It actually is widely worded, but it still, my lord, involves the state, it involves the legislature, it involves the Constituent Assembly. Mr. Sybil, my lord, is perfectly right when he says that those who have actually lived by the sword of the proviso and have taken recourse to Article 367, they must actually be tested on that basis. But, my lord, I am going to deal with the argument fully. But I'm going to put it in very simple words. First was, you can ignore the proviso. Second was, what is this word recommendation? It's a recommendation. You are the ultimate. You're the president. But my lord, recommendation of a constituent assembly in a context in which that word is placed in sub-article 3, my lord, tells us that it is a condition precedent. Gopalaswamy Iyengar definitely called it a condition precedent, but my lord, on principles of constitutional construction, you would be justified in interpreting it as a condition precedent, which means, my lord, if that condition precedent was not satisfied, the power was unavailable. This is not a normal proviso. And my lord, marginal notes with great respect. After Keshavananda Bharati, all the learned judges said it doesn't control a constitutional provision. But I'm starting, my lord. Yes, we thought it was temporal. But by the will of people, it became a mainstay. Now, my lord, there was also a suggestion. There is a power coupled with a duty to abrogate Article 370 because of this marginal note. My lord, power coupled with a duty can sometimes be implied, but here it is a self-contained code, Article 370. The duties lie within Article 370. The assumption of a duty, my lord, outside the Constitution is never permissible.
Mr. Subramaniam, I think we have given you sufficient time in a rejoinder now.
Yes, my lord, I'm quickly galloping.
Yeah.
My lord, I can't look galloping, but I'm galloping. I'm galloping, my lord. I wouldn't necessarily, my lord, inflict on you a little more than needed. No. My lord, I'm only referring to the nature of the arguments with reference to marginal notes, with reference to the proviso, and I'm saying, my lord, that they are completely untenable. But, my lord, there is also something which must be brought to your lordship's notice. There was this 1952 agreement. We all had a summary. We were looking for something more authentic. Then my Lord Justice Gavai rightly said that, well, it has at least been introduced by the Prime Minister of Jammu and Kashmir in the Constituent Assembly. My Lord, this was also introduced by the Prime Minister in Parliament, the 52 agreement. And your lordships, I'm just giving the pages only the pages. It is in volume D9. The relevant pages are 53, 54, D9. My lord. These are parliamentary debates, 53, 54, 55, and 96. Now, my lord, I come to Parate's case.
These are the parliamentary debates on?
On, my lord, the 1952 agreement. There was a motion. It was brought to the House, my lord. It was discussed before Parliament. And of course, my lord, it's a pretty long speech, but the Prime Minister spoke about this agreement, and they seemed broadly an item with what Prime Minister of Jammu and Kashmir said. Now, my lord, we come to 2 points, and I'm finished. Article 3, Babulal Parate. My lord, Babulal Parate's case is distinguishable. That, my lord, is to be found in Case Law Compilation 6 at page 124.
124.
Yes. And what is significant, my lord, is Justice Das says in our Article 3, we do not have a similar provision like the corresponding article in the American Constitution that the consent of a state legislature is necessary. This is very important, my lord. This is what Justice Das observes correctly. And now, my lord, if you see the 1954 order and the proviso to Article 3, it is precisely that provision in the American Constitution.
You are at page?
Page, my lord, 121 at 124 in volume C6. And then, my lord, I now deal with one point quickly, which is privy purses. My lords, there is no analogy between privy purses in this case. Privy purses, my lord, is a case of ex-rulers. Here, my lord, sovereignty passed on to the people in Jammu and Kashmir already. And even the judgment, which has been relied upon very heavily, my lord, which is Raghunath Ganpat Rao's case in volume C7, 537 at 562, my lord, Justice Pandian speaks glowingly about one basic feature of the Constitution called political justice, political rights. Political justice and political rights, Justice Pandian says, has not been touched by the Constitution 26th Amendment. Well, on that very passage, I rely upon to say, in our case, what we are dealing with, my lord, is not only the Constitution, we are also dealing with the class of rights which have been guaranteed to people in Jammu and Kashmir, both under the Indian Constitution and the Jammu and Kashmir Constitution. I would therefore, my lord, respectfully submit that the outcomes of integration, my lord, have been achieved. We may have different perspectives on it, my lord, but we are now only dealing with the validity. And my lord, 356, with very great respect, my lord, is never intended to use for the purpose of usurping state legislatures as bodies ear nominee by Parliament. No, my lord, it cannot be done. That notional